topic of discussion today will be grand juries. There's been much news coverage about grand juries and the cases that are presented to the grand jury, be it state or federal. And that discussion has been riveted around, as we all know, Ferguson-type investigations, namely police shootings. And I think that it's apropos to talk about the nature of the grand jury system, to talk about the inequities, plus the solid good points of the grand jury. Initially, when grand juries were first established as part of our criminal justice system, the purpose was to protect the innocent from being unjustifiably prosecuted. Thus, we have the beginnings of the confidentiality of the grand jury. And I think that purpose is well placed. The confidentiality in place protects the reputation and was meant to protect the reputation of individuals that have their cases heard before a grand jury. Today, grand juries are necessary in order to combat felony accusations in a district criminal court, be it state or federal. In order to have a trial, be it state or federal, one must have an indictment handed down by a grand jury. An indictment is simply a determination that there is probable cause to believe that an offense was committed and that the individual that is accused of committing the offense did commit the offense. But it's simply a probable cause determination. Unlike what we hear in the paper, grand juries do not determine guilt or innocence. That is not the purpose of the grand jury. We have a lot of situations that recently have developed that reflect the fact that the citizens of this country believe that grand juries hand down verdicts of guilt or innocence, and that is not the case. I want to talk a little bit about the grand jury and the sources of information that the grand jury can use in order to initiate an investigation. Grand juries can obtain information from any source whatsoever. A news report, a newspaper article, an individual who files a complaint. Those sources are not limited. Grand juries do not need the district attorney's office in order to investigate a particular cause that the grand jury sees fit for investigation. The district attorney's office, in turn, presents cases to the grand jury simply because they are the collection agency that, in almost every instance, obtains information pertaining to an investigation of a criminal nature. That information is then presented to a grand jury through a district attorney. Now, is it necessary for the defense lawyer to go through the district attorney's office in order to present or ask that information be investigated by a grand jury? And the answer is no. The individual defense lawyer can put together a packet, take it to the clerk, and ask that when Mr. Jones's case comes up for consideration by the grand jury, we would like this packet presented to the grand jury. That is normally not the process that takes place. A individual packet, and I urge every defense lawyer to take the opportunity to present packets of information favorable to your client. Have 13 ready to go, one for the prosecutor. There are 12 grand jurors that consist of each grand jury. It takes 9 grand jurors to return a true bill of indictment. If only 8 are present, then the grand jury probably will roll over that particular investigation. Police shootings, like every profession, the law enforcement agencies, in my opinion, are above board, and we want them to be above board because we look upon them, we being the citizens of this community as well as individual grand jurors, look upon law enforcement favorably. We are asking them to protect our safety. But as in every profession, be it legal, judicial, or law enforcement, there are occasionally bad apples. That comes now to the point of whether or not the district attorney's office is equipped and should be both ethically and legally equipped to investigate a police shooting and present evidence in front of a grand jury for determination as to whether or not to indict, based on probable cause, a particular officer in the shooting of an individual. I am of the opinion that a district attorney, be it state or federal, that presents a law officer who is charged with any type of offense is basically involved in a conflict of interest. I say that because law enforcement and district attorneys frequently work hand in glove outside of the grand jury system on cases that the district attorney's office might be presenting to a jury of 12. Law enforcement, police officers are witnesses in almost invariably every case that comes before a jury of 12 people. And the district attorney's office presents that law enforcement officer. I am of the opinion that there should be an independent attorney selected by the judge of the particular grand jury and whose district court has the authority to make determinations as to and selection of grand jurors. That judge should also have the opportunity to select an attorney to preside over the investigation in front of a grand jury of a law enforcement officer involved in a police shooting. That would eliminate, in my opinion, a great deal of dissatisfaction and the appearance of impropriety when the same individual that perhaps is involved in the investigation of the case with the district attorney's office presents an individual law enforcement officer for a determination by a grand jury as to whether or not that individual should be indicted. Another point that needs to be addressed: does the accused have a right to have his or her lawyer in front of the grand jury? The answer is no, unless the district attorney's office grants permission to the attorney to appear. That's happened to me on a couple of occasions in the past where I've been able to appear in front of a grand jury on behalf of my client. Never failed to ask permission of the district attorney to be permitted to be present to present your side of the story to the grand jury. It's an invaluable opportunity, and it so happens that each time it's happened to me, success with a no bill has been the result. The individual who appears in front of the grand jury to testify, and there are pros and cons, of course, about having an individual appear in front of a grand jury, because that individual will be Mirandized, and that individual will be questioned under oath aggressively by the district attorney without having the defense lawyer present. The defendant or suspected defendant is always advised that he or she may go outside and talk to their lawyer if there's a question that they have need to ask for legal counsel. If that person in front of the grand jury invokes that right in front of the grand jury, I will guarantee you that that person is going to be indicted, because it will always tell the grand jury that the individual has something to hide if that person goes and talks to his or her criminal defense lawyer. The better part of the decision as to whether or not to put an individual in front of a grand jury. Under exceptional circumstances, you do, but the circumstances absolutely have to be extreme. Not only does the individual, for instance, face the possibility of having another charge of aggravated perjury investigated by another grand jury, but also that story, if the individual is indicted, is already heard by the district attorney's office, and his or her testimony can be used to impeach anything that happens down the road if an indictment takes place, followed by a trial of that individual. Federal grand juries are much the same. District attorneys are not handcuffed figuratively in being able to select the type of information that he or she presents to a federal grand jury. There are instances where false information has been provided to federal grand juries, and case law reflect that, given the fact situation, that's not necessarily grounds to throw out the indictment.